So when we get a call and someone says they have a brain injury case and they'd like to talk to you, how do you go about first putting a brain injury case together?
Well, to begin with, a brain injury case is a personal injury case. If you don't have the elements of a successful personal injury case, it doesn't matter how serious a brain injury a person has, they're not going to recover in court. And there are three primary elements to a personal injury case. And I'm a personal injury lawyer, and that means that I work on a contingent fee, and if we don't recover for the client, we don't get paid. But it's not just that we don't get paid, it's that we have to risk our own capital, our own money, to invest in their cases. I talked about expert witnesses. The expert witnesses in a normal brain injury case that goes to trial are going to cost the personal injury lawyer as much as $100,000 of his own money. If the jury doesn't find for his client or finds for significantly less than the amount invested, the lawyer is not only not going to collect the fee, he's going to lose that money out of pocket. And we've done that. Most personal injury lawyers like to talk about all the great cases we've won. We've learned as much from the cases we've lost. And we've lost cases, and I know you and I both carry some of those losses with us as we go forward. And the pain that we felt for our client when we lost is something that we can't ever really erase, even if after we recovered from the economic loss of $100,000 or $200,000 out of pocket in those cases. To make a case work, first you've got to be able to prove that someone else was at fault, and we call that liability. You have to be able to prove that you're injured because of the wrongful conduct of someone else. In most cases, that wrongful conduct is negligence. Now, negligence is easy to understand when you're talking about getting rear-ended in an automobile accident or another car coming across the roadway. In a sense, negligence is the violation of some rule of conduct, even if it's not a law, that the reasonable person would do. So the first thing you have to do, look at to determine whether someone has a personal injury case, is to determine whether or not someone else was negligent. Now, sometimes there's more negligence than you realize. We just finished a major case in Washington where we recovered a substantial amount of money from a party who wasn't obviously at fault. In that case, it was the county for putting a yield sign up instead of a stop sign. Sometimes a driver that you would think was just only nominally at fault can actually be found enough at fault to recover from. Those are the kind of things that must be evaluated by a personal injury attorney who takes more than a minute or two to listen to figure out. In the case in Washington, it would have been very simple to have settled that case for the policy limits of the other at-fault driver. But we were able to get considerably more because we actually took the time and investigated. So the first thing you have to do is find liability, and if there's any question, you have to do a thorough investigation to determine it. The second thing is you have to have liability against someone who has the ability to pay if you get a judgment. Brain injury cases are not $25,000 or $50,000 cases. The kind of brain injury cases that involve disability will typically have values well above $500,000, and in many cases, depending on the impact on the person's ability to earn, could be many millions of dollars. Depending on the person's, likewise, if the person has significant care needs in the future, it can be millions of dollars. These are not cases that you can bring with someone against someone who has a $25,000 insurance policy on their car. The greatest majority of people have what they call $100,000, $300,000 policies. Those are very difficult to bring a case unless there is something else, some other party involved, or it's really straightforward. And most brain injury cases that don't involve hundreds of thousands of dollars in medical bills are not that straightforward. They can be very challenging. The third thing, you've got liability. You have to have a collectible defendant. And the third thing, of course, is you have to have significant damages. An example of a case that wouldn't have significant damages is how my case, when I was 21, would have been perceived of by a lawyer who, had I gone to one, he would have looked at the medical bills. I only saw a doctor on the day of the accident. My medical bills were an ambulance ride, an x-ray, and whatever the emergency room charged at the time. Now, medical bills have considerably grown since then, but my medical bills at that time were probably $200. If that had been the extent of my diagnosis, that is a case that wouldn't make sense for a lawyer to take, because the amount of money to recover would be considerably less than the amount of money the lawyer would have to expend to prove that case. Now, in the contrast, had I not recovered in the time frame that I did, had I not been able to go to law school, had I not ever been able to hold a regular job, you could say that the case could have value of millions of dollars. I've made a substantial amount of money over my career, and had that accident been a little different, I've been hurt a little bit worse, or adapted a little bit differently than I did, or maybe even been a few years older, and not had as good a recovery, the damages could have been quite significant. So